the right to equality of opportunity in public employment. Article 16 is located within Part 3 of the Constitution of India, in the Fundamental Rights chapter, which comprises Articles 12 to 35. In fact, Article 16 is a very important constituent of the right to equality ensured to every citizen through Articles 14 to 18. Indeed, it seeks to realize the preamble's ideal of providing equality of status and of opportunity. Let's closely examine Article 16. Article 16's title reads, Equality of Opportunity in Matters of Public Employment. Thus, the term matters here will refer to all matters related to employment, such as appointment, promotion, termination, etc. And when you put Article 16 alongside Article 14, the right to equality, you see some very important contrasts. Article 14 provides for the general principle of equality, while Article 16 talks about the specific area of equality of opportunity in matters of public employment. Also, Article 14 is applicable to all persons within the territory of India, including foreigners and tourists, while Article 16 is only meant for citizens of the country. Article 16 will therefore cover very many facets of public employment. It comprises Article 16 Clause 1, Clause 2, Clause 3, Clause 4 and Clause 5 since the commencement of the Constitution. Article 16 Clause 4A and Article 16 Clause 4B were added through subsequent amendments, as was Article 16 Clause 6. Now we move on to look at the very first clause of Article 16. Article 16 Clause 1. Article 16 Clause 1 provides that every citizen has a right to equal opportunity to employment under the government. What this means is that there will be guaranteed equality of opportunity to seek government employment, and not a guarantee of employment itself. There is thus equality of opportunity. So this is not the same as the guarantee of job. So each one of us can apply to any post under the government, because such post is freely and publicly advertised, thus ensuring each one of us equality of opportunity. Of course, we are required to have the requisite eligibility or qualification for the post thus advertised. Secondly, Article 16 provides for equality of opportunity only with regard to government jobs and not private jobs. Besides, such government jobs must be those that are substantive or permanent in nature. Article 16 also will not be applicable to any contract or temporary positions, even when held within government offices. Moving on to Article 16 Clause 2. Article 16 Clause 2 provides clearly for non-discrimination with regard to government employment. Thus, it is almost like Article 15 Clause 2, which also prohibits discrimination. The only difference, however, is that while Article 15 prohibits discrimination on the 5 grounds of religion, race, caste, sex, place of birth, Article 16 Clause 2 brings in 2 additional grounds. It says that no citizen can be denied equal opportunity to seek public employment on the grounds of religion, race, caste, sex, place of birth, but also descent and place of residence. Moving on to Article 16 Clause 3. Now, often it is seen that a certain region within the state lags far behind the others. There may be a very low rate of development, or there may be widespread poverty in such region within the state. Now, in order to ensure that the people of these backward regions have a chance to come forward, the state may require certain state jobs to recruit from candidates who locally reside in such region. To give this effect, the Parliament of India passed the Public Employment Requirement as to Residence Act 1957. Under this act, the states of Himachal Pradesh, Andhra Pradesh, Tripura, and Manipur were empowered to advertise posts to which only the residents of those states had a claim or could apply. This provision also exists in Article 371D of the Constitution, which provides that in the state of Andhra Pradesh, the government may make public appointments from amongst residents of that state. Moving forward to Article 14, Clause 4. This article really lays down the basis of reservation in government employment. It says that the backward classes of citizens, such as the SCs, STs, and the OBCs, will have reservation in government posts. With regard to the SC/ST reservation, the Parliament in fact legislated that the SC/ST would have a total of 22.5% reservation ever since the commencement of the Constitution. Also remember that under Article 340, the President of India can constitute a commission to study the problems of the backward classes, also known as the socially and educationally backward classes. Now, the reservation of 22.5% for SC/ST soon gave birth to the carry forward rule. Now, the carry forward rule was simply stating a rule by which the state was free to carry forward any unfilled vacancy from the previous year. To understand this, let's do a simple calculation. Say in the year 1951, out of 100 posts, 22 are reserved for easy understanding. That is a reservation 22.5 for the SC/ST. Now 12 appointments are made while 10 posts cannot be filled. Now these remaining 10 persons that cannot be filled in 1951 will be added to the reservation for the next employment announcement. Now say the next announcement happens in the year 1955. This time there is again the 22% SC/ST reservation, and this time it is seen that 4% of reserved vacancies are filled. Thus 18% posts remain unfulfilled as no general category candidate can take up a reserved post. Add to this the 10% remaining from previous time, and the total carry forward is 28%. Now, coming to the next year, which is 1958, when the government again advertises for fresh government posts. Out of 22% reservation vacancies this time, 11% are filled. Remains 11% more. Add to this the 28% carry forward from last time, and there is a whopping 39% reservation. Say the government again carries forward these reservations to the next appointment cycle in 1960. And this time again 6% posts are filled. The remaining 16%, to which the 39% of the previous cycles will be added, will now stand at a total of 55%. And this again will be carried forward to the next appointment cycle. This came to a point where in 1961 it was seen that the number of reserved posts stood at almost 62% of the total posts advertised. It was at this juncture that this question of reservation of government post was examined by two very important Supreme Court judgments. The first of these is Devdasan versus Union of India. In this case, the Supreme Court held that if the carry forward rule applied by the government comes to a maximum of 50%, the excess appointment will not be done. That is, the carry forward rule should be less than 50%. The other case was that of Indra Sone versus Union of India. In this case, the Supreme Court said that the backward class reservation, which was of 27% for OBCs, as suggested by the Mandal Commission, is upheld, but the creamy layer existing within the OBC category must be defined and segregated so that the benefit of reservation can indeed percolate down to the lowest. Secondly, this judgment also held that such reservation is only applicable for appointments and not promotions. The judgment made it clear that reservation cannot exceed 50% except in special circumstances. It also held that the government's carry forward rule is unconstitutional. However, let's move forward and look at Article 16 Clause 4A. This article was added in the year 1995 through the 77th Amendment Act to provide reservation also in the matter of promotion. So, reservation could now be applied for not just appointment but also promotion. The 85th Amendment Act, made in 2001, also added the phrase consequential seniority to Article 16, Clause 4A. This amendment, which applied reservation in the matter of employment, was, however, meant for only the scheduled caste and the scheduled tribes. It did not extend its protection to the OBCs. Article 16, Clause 4B was added through the 81st Amendment Act of 2000, and it brought back the government's carry forward rule. In fact, Article 16, Clause 4B provided that the carry forward rule of the government in case of posts reserved for the scheduled castes and scheduled tribes and the other backward classes or the OBCs would continue, and such continuation may be in excess of the 50% ceiling. We now come to Article 16, Clause 5. Article 16, Clause 5 provides that where a religious position or post is involved in an institution which requires the post to be filled by a candidate of the same religion, the vacancy is to be filled as such. So, say for instance, a religious institution such as a mosque or a church or a temple is well within its right to appoint its priest or Maulvi or any other official position from amongst candidates of like religion or faith. We come to the last clause of Article 16, Article 16, Clause 6. Added in 2019 through the 103rd Amendment Act, Article 16, Clause 6 accords reservation benefits in government employment to the economically weaker section among the general or unreserved castes. In other words, Article 16, Clause 6 identifies a new category of reservation, and that is the economically weaker section. A link to understanding the economically weaker section is mentioned in the description box. This reservation is to be for a maximum of 10%, and such 10% reservation for the economically weaker section will be in addition to the 50% that already exists for the SCs, STs and OBCs together. Thus, Article 16 lays down the provisions with respect to equality of opportunity in public employment. It can be said that Article 16 was instituted as a push forward for the backward classes in society.